few empty seats last time.
Good morning, all.
Yeah, I suppose people want to get away or something.
Sure.
I guess, yeah.
Good morning. We're going to begin the program now.
Yeah, it's close. Next week is, but
I understand there's some people still coming. They'll be drifting in, I think, mostly through the back over the next half hour or so. I'm Paul Truster, head of CLE for the Law Society, and on behalf of the Law Society and the Canadian Bar Association Ontario, I'd like to welcome you all to today's program. Because we are running a little behind time, I'm going to keep these announcements to an absolute minimum. I do want to thank all our faculty who have prepared the presentations that you'll see in here and the materials which you don't presently have. They've given very generously of their time and talents in preparing all this. We're completely dependent on their efforts, and we're certainly grateful to them. About those materials, they were delivered to the Law Society at 4:30 p.m. yesterday, and their present whereabouts are unknown. If anyone sees anything suspicious, like U of T law students in the building, just please, just kidding. If the materials are located during the program, they will of course be brought to the registration desk, and an announcement will be made concerning them. If they are found after the fact or have to be reprinted, then they'll be sent out to each of you one way or another. You will receive the materials. I'm now very pleased to turn the podium over to Leonard Gangbar, sitting at my right here, and he'll be the first to speak to you. Thank you.
It's amazing how they never lose the checks that they have to mail to us for our filing fees. Good morning and welcome to an introduction to the world of electronic registration. This morning we will hear from Kate, Randy, Maurizio, Kim, and others about the world of electronic registration and the groundbreaking concepts with which we must all become familiar. From the acknowledgement and direction to the document registration agreement to the electronic transfer of funds for land transfer tax and registration fees, to the compliance with law statements. Electronic registration will precipitate fundamental changes to the way that each of us practices real estate. We must all become familiar and comfortable with paperless conveyances of interest in land, where documents will be drafted, approved, exchanged, and registered electronically, where transfers and charges will not require the direct signature of the parties to have legal effect, as well as becoming comfortable with the ability to remotely access the electronic system in dealing with searches, conveyances, and charges of title. Electronic registration will also significantly alter the way in which we interact with one another, and it will forever alter some of the traditional methods of the daily practice in our field of law. Physical attendances at the registry office to carry out searches of title and meet with a vendor or purchaser's agents to complete a transaction will become a memory of a distant past. Each of us will be challenged to work our way through an electronic environment, and we will be continually challenged to stay abreast of the continuing technological innovations which will continue to occur. We will each need to acquire the requisite skills and knowledge to work in this new environment. I am certain that there are very few people in this room who would not agree that they are apprehensive and uncertain of the changes facing us. But change, as they say, is inevitable, and we have all succeeded in the past to adapt to change and to succeed and thrive in the face of change. The majority of practitioners in this room experience the tremendous changes brought to our daily practice with the introduction of the Land Registration Reform Act, the Planning Act, the Condominium Act, and the impact of title insurance. In each case, the real estate bar has excelled in adjusting to these fundamental changes in the practice of real estate, and we have each continued to succeed and thrive in the face of these changes. The same success will, I have no doubt, follow with electronic registration. Before I proceed to the introductions this morning, I'd like to take an opportunity to thank our sponsors, Teranet, Title Plus, and BarX, as well as the staff of the Law Society and the CBAO, without whose tireless efforts these programs would not be a success. I'd also like to take an opportunity to remind you of the upcoming CBAO luncheon program on February 28th, where we pit borrower and lenders counsel one another at a topic entitled Acting for the Borrower, Where to Draw the Line in the Sand. Kate Murray, who will be our first speaker this morning, is currently the Director of Land Titles with the Ministry of Consumer and Commercial Affairs, formerly with the Attorney General of Alberta as counsel to the Alberta Land Title System. She was called to the Alberta and Ontario bars in 1979 and and 1989 respectively, and is a member and terrific contributor to the Real Property Executive of the Canadian Bar Association. Kate will address Polaris conversion and e-reg statements.
Thanks, Leonard. Good morning, everyone. Actually, the first thing comes out of Leonard's comments. Oh, that's quite dark. We recently, with change of minister, also changed the name of the ministry, and it's now known as Consumer and Business Services. No, it's hot. Yeah. Okay. Okay. This morning, I'm going to speak to you about the legislative framework and the regulations behind electronic registration, and I can barely see my notes, so be winging this. But I think the first thing that I'd like to talk about, and it's really a little bit off the agenda, has to go to the operations of the registry office and the relationship between Terranet, the ministry, what TerraView is, what Polaris is, just brief comment, because when I come to these events, I find that there seems to be some confusion on that, and I think understanding that that item sort of leads to, I think, understanding the system a little bit better. I think that I'll start with the electronic registration system is delivered through the TerraView product and gateway called TerraView. It interacts with Polaris, which you're all familiar with, which is where the ministry's records are kept. In this relationship, the government still runs the land registration system, still sets the legislation, still sets the regulations, and still sets all the procedural rules with respect to registration. So in other words, when you're registering a document, you'll be dealing through the TerraView gateway, but you're still going and interacting in a different format with the registry office, as you are familiar with doing now. In this process of changing the way we interact with you, the registrants, we've been working very closely, obviously, with Terranet, as it's the TerraView product, with the Law Society and the Canadian Bar, and we will continue to do so. And as you'll see this morning, as we go through the different presentations, as you have questions and comments, with us, we take those in consideration as we do make changes to procedures, as Terranet makes changes to the software, and the Law Society and Canadian Bar in terms of practice issues. So let me start now with the legislative framework. Okay. All of you are familiar with the Land Registration Reform Act because it's the act that's, when passed in 1984, was quite revolutionary and affected a lot of change to the land registration system. Part 1 of the Act allowed for all the changes that we're all so used to now, the new forms, the Polaris forms, the covenants, simplifying the documents that are registered and how we register them. Part 2 enabled the automation of the records, and now Part 3, passed in 1994, enables electronic registration. Since the late 80s, the ministry and Terranet have been involved in automating the records and converting them to land titles. And it's through this conversion to land titles we're able to offer electronic registration, because electronic registration is only available to land titles documents. Okay. Now, Part 3 of the Land Registration Reform Act is quite short, but has a few key concepts that are obviously very fundamental to electronic registration. The first, and probably the most revolutionary, is the removal of the requirement for the physical signature to documents. Documents are now signed electronically, and there'll be discussion of that later this morning. The Act also enables the direct electronic submission of documents to the electronic database. And the Act also provides that the electronic document prevails over a written form of it. Now, in introducing electronic registration, we've continued the use of statements, which you're familiar with from the Polaris forms, and also introduced the concept of law statements. law statements and compliance with law statements will be discussed more this morning, but when using those law statements, the TerraView software is linked to the Law Society software, and it ensures that people signing the law statements are in fact lawyers entitled to practice in the province. Now, finally, when we passed the legislation, Part 3 of the Land Registration Reform Act in '94, we made commitments to the Canadian Bar and the Law Society and others that we would do extensive consultation, and it's from those consultation that we developed the registration rules in the regulations. Now, I know you have the materials aren't here, and I actually don't think that the regulations are in the materials this morning. However, if you have access to, there's a number of different Canadian bar materials, which I've included the comments on the regulations and also the regulations themselves. They're also in the Law Society's Bar Admission Program, and they're available in our bulletins from the registry office as well. But in these regulations, when you look at them, they're a new form of regulations from what we're used to. We no longer prescribe the form. We just prescribe the information that's required to be submitted. In electronic registration, the Polaris forms, the forms that were brought in 1984, are not applicable. And I think when you go through them, you'll find that the information that is prescribed as being required is information that you're very used to giving to us. It is either the same or very similar to what you're used to now. It's just the way you're giving us the information that's different. Now, as I said, attached to the bulletins or in those materials, you'll see a series of regulations passed in January of '99. But the main one in terms of registration, once you go through them to see that it says that, you know, it applies only to land titles and that kind of thing, you'll see the main regulation is OREG 1999. When you go through, it's set up systematically. Section 4 talks about the general requirements of any document. And then the regulations go through and talk specifically about transfers, then charges, and then discharges. And then from there, there's a separate section on the different applications that you're used to now giving us in a Form General. At the end of the day, once you go through those regulations and you see that the information is similar, and then you go to the TerraView system, you'll find that the way the system has been designed is that if you click the right statements and you fill in the right screens and the right fields on those screens, that for the most part you've complied with the regulations. They were designed so that they comply with the regulations. Behind those screens and in the system, we've also built in logic so that the system checks to make sure that if you select one statement and by accident you select a statement that conflicts, the system will come back and give you an error message. So once you've gone through and you've registered a document, you should find that that you've complied with the regs, and there should be very little reason for the office to contact you for changes. Now, finally, in that OREG 1999, you'll see at the end there's a section 40, and it talks about law statements. The law statements are primarily to do with estates and powers of sale. And I think Kathleen later gets into, sorry, what the compliance with law statement is. It's where we ask a lawyer to give us a conclusion of law. They must be, as I said earlier, a solicitor who is entitled to practice. And the section 40 states that when you're giving statements and it's a statement of fact, it is the statement from your client. It's not your statement from that perspective. So I'm going to conclude now, but encourage you thank you for coming this morning, encourage you to get on the system early and practice. I think that's really the issue, getting used to the different format. And once you do, I think you'll find that, as I said, the information we require is very, very similar to what you're used to now, and that you'll find it useful in your practice. Thank you.
Thank you, Kate. Our second speaker this morning is Randy Reese. He's currently with the Real Property Branch at the Ministry, where he acts as project manager for a number of electronic service delivery projects, including electronic land registration. Prior to this, he was deputy director with the Personal Property Security Branch, where he was responsible for moving that branch from a paper to an electronic environment. Randy will provide us with an update on the introduction of electronic registration.
Yes. Thanks, Lynn.
Do you want me to do that, Randy?
No, I'm okay. Yeah, I can use it. Good morning, everyone. I guess if we can get the lights dimmed, it would probably help you see the screens. Okay, what I want to talk to you about this morning is a few things. One's the ministry experience, what we've seen so far and how things have worked for us. I want to talk to you at a very high level, I guess, of how the system works, and that's really what the first slide is all about. But I think the key thing to keep in mind is that you still have to search, you still have to create documents, and you still have to submit them. It's just that the tools that you now have are different, and they've changed. And I want to give you some statistics about what we've seen in the offices that have electronic registration so far. And I want to tell you what to expect if you go into a registry office after we've gone into a second reg environment. So the first slide that's up here, and I hope everybody can see it, it's really, no? It's too bright, so maybe, hopefully we can put the lights down and I can read still with in the dark. Is that better? Yeah? Okay.
They should reverse it. The lights are on at the back, and not.
Yeah.
Yeah. Can you read? This one.
Yeah, hopefully everybody can see that. Yes, no? Okay. No? Now I can't see anything. That's even better. I guess we'll just have to get by without it. I can make these copies available afterwards if people need them through the society. So what happens when you log on to the system? And some people who've had it, I mean, this is very high level, but I want to give you some idea of what to expect. You log on to the system, and once you're into the system, what you will then do is identify the type of document that you're going to create. And there are a number of different types of documents, but they're all more or less variations of the 4 standard ones that you're familiar with today. You enter, in most cases, the PIN number. In some cases, it's the document registration number. And what the system does is pre-populate information into your system. So it comes right out of the Polaris system, and it brings in information such as the property description and the current owners and whatnot. You then make statements that are appropriate to the information that's there, and you also add additional information like who's purchasing the property. The document can be forwarded electronically to the solicitor for the other side, so you can send that back and forth. You can do things that you need to do, and the other party can do things they need to do. Then you submit the document for receipt into the system. And what happens at that time is the system performs a number of edits to tell you if you've made any mistakes. Those edits try as best possible to kind of mirror what we do at the counter now when we check over a document. However, it can't do everything that our people do, but it does do some edits for you, and it does provide you with information if you've made any mistakes. You then submit the document for receipt. You get back a registration number virtually immediately, and the system also provides you with a copy of the document, so that's printed out automatically on your printer in your office. The LRO staff continue to review the documents in the office, so the certification process doesn't change. We continue to do that. We continue to certify behind the scenes before we, this thing's going to sleep, okay. Before we update the title on the record. What we will do if we're going to send a document back for correction is we call people first and we advise them it's coming back. The document is sent back electronically, and then you then have to resubmit it, although you keep your registration number. That does not change. The implementation process, how this thing is being rolled out. It's going to be rolled out on a county-by-county basis, starting in Middlesex, which was the pilot office. We pass a regulation in that jurisdiction that makes electronic registration optional. So you have the option of filing electronically. However, you can still submit paper at that time. We tend to call this the transition phase. We pass a second reg, and our commitment is to do that a minimum of 60 days, at least gives you 60 days notice of that. So far, that's been considerably longer than that, but hopefully we'll be able to tighten this up as we start to roll out across the province. But once the second regulation is passed, you're then required to submit the majority of your documents electronically. And I say the majority, it's probably around 97, 98%. There are some things the system can't handle, and those you can continue to submit paper documents. Things such as registry properties that still may be in one of the offices. There are 3 options. No, I'll go back one point. Any documents that were executed prior to the filing of a second reg. So we give a notice, we provide you with a date. Any documents filed prior to that, you can still submit paper documents, provided they were signed prior to the second reg date. You have three options for filing electronically. You can do it remotely using the TerraView software, and that is what we believe is the preferred method, and which we hope most people will do. There's a kiosk or kiosks in the registry office where you can go and use the TerraView system, but you still have to have a security pass, and you still have to be registered with TerraNet to use that. So you'd log on using your own security credentials, or you can use staff assistance. So we will actually create the electronic document for you. It's not the recommended option only because you're going to find it takes us much longer now to do that, since we're effectively creating the document for you. And I think our message has been consistent throughout the province that if you're in the business of real estate, you will not want to be going to the registry office and having our staff create documents. It's just going to take too long. The next slide shows you where electronic registration is currently available. In Middlesex, it's there, and they have dates up there for both the optional filing date and the mandatory date. Middlesex, of course, it's mandatory and has been since March 7th, 2000, so we're getting awful close to the first year. Hamilton, we went with a second reg on January the 29th this year, so they've been at it about a month now. Halton, they're currently an optional, but we've announced a date, and I hope people can see it. I haven't read up there. It's April 25th of this year where we'll be going mandatory in Halton. And there's two other regions where it's currently optional, and that's Peel and Dufferin. We have not set dates yet for the mandatory phase of that. The next slide that I brought up, it's kind of interesting because this tells us what happened in Middlesex both prior to the second reg and after the second reg. And I'm going to bring the bars up there. It was kind of interesting because we did not know what to expect once we hit a second reg. There's no other jurisdictions who've done this, so we didn't have any place we could call and say, what was your experience? So quite frankly, we were a little bit concerned, probably a lot more than concerned, what was going to happen on that date. Because you'll see when the first bar comes up there, it's quite small. That represents a whole year, the year between first reg and second reg, when the uptake was virtually, well, I will say virtually nothing. It was about 3 or 4%. So very few people were using the system at this time. We were concerned that if everybody's going to walk into the office after March 7th, what we were going to do, because it was going to be quite a job trying to get people registered, especially on a busy month end. So we made the announcement in December. You can see in January the uptake starts to creep up to around 10%. Now this represents the number of documents submitted electronically by clients from their offices. So they're not coming into the office. We're only 10%. We're now about a month away. February we creep up a bit more. March 7th is kind of the deadline on this thing. And then as we get into March, it started to jump up at about 30%, but we're still filtering the paper out of the system, documents signed prior to March 7th. So what was going to happen in April and May, nobody really knew, but as you can start to see these bars as they come across, virtually everybody, and this takes us right up to November, it hasn't changed, virtually everybody started filing remotely, which we breathed a huge sigh of relief. We're up to about 95%, and that's holding, that's staying there in Middlesex. So what we're finding in Middlesex, 95% of all the documents are coming in electronically by clients. We're getting about 2.5% paper, which was expected, and the other couple percent are people coming into the office using staff assistance. And that on many days that we're quite thankful for is nothing. I mean, I think the biggest day I've seen in Middlesex has been 7 documents, and many days there just haven't been any. Some numbers up here for you. We've done over 40,000 documents in Middlesex alone now remotely that have been successfully submitted. So the system works. I mean, we've seen virtually every type of document that can be submitted, and we know it works. As I mentioned, 95% are now being submitted remotely by clients. Virtually no one is using staff assistance, and about 4% of the documents now are now being returned. This is in Middlesex, are being returned for correction, and that was over 10% in the beginning. And that's to be expected as people get used to using the system. They get better at it and make fewer mistakes. And so we're thankful that that's down. We've gone through 11 month ends now, and that seems to be everybody's big concern, what happens at month end. We've not had any problems at month end where they've gone through without any incidents. And the system uptime so far is over 99%. There have been some outages, usually for an hour or two, but nothing significant yet. The next... And I say yet because you know what things can happen. The next chart really shows you the 3 offices and where they go. And you can see the uptake's very small in July, and these kind of mirror the dates that these offices came online. As we get to the end, you get a big spike. In the Hamilton graph, we're up over 60% now after the first month. So that was actually better than Middlesex, because I think Middlesex after the first month was only about 30-odd%. So we're hopeful and we're expecting that in Hamilton, which is now in a mandatory environment, we're going to be up to that 95% level probably next month. We would like to see a little more uptake during that transition phase. We're finding still a lot of people wait to the last minute and then try to get on and start to scramble and panic. In the case of Hamilton, they've had probably, I think, about 6 months to get ready. A lot of people have waited. We're seeing I'd say relatively good, but it's not too bad in Halton. We're around 25, 26%. But still, we'd like to get that number up higher. You've got now 3 months or so to get ready before it comes in. The next little graph shows you some numbers, or chart shows you some numbers in Wentworth, Halton, and Peel. Got Wentworth up there. I guess it's Hamilton now. 3,400 have been filed electronically there, 5,100 in Halton, 3,700 in Peel. So I think if you add them all up, we're about 52,000 electronic documents now have been filed into the system. Unfortunately, in those mandatory jurisdictions, although we're seeing some pretty good numbers, most of them are coming from the financial institutions. They've made a commitment almost from the beginning that once we go optional in a jurisdiction, they will start submitting their documents, which are mainly discharges and transfers of mortgage electronically, and they seem to be doing pretty good at that. So we'd like to see the other clients starting to use this thing more. Just a little bit of miscellaneous information. January 25th, and I only put this up here because we had the world's first, and the world's first filer is here to talk today was Kim Little. He filed a discharge on that day, but it was the world's first truly electronic document. This had never been done in any other jurisdiction where we had a pure electronic document. On October 16th of last year, we released a new version, TerraView 4.2. Everybody should have been sent that copy, and if you have the software and you haven't upgraded, I would certainly encourage you to do so because it contains a number of enhancements that you will find useful. Not the least of which is getting a copy of your document immediately once you submit it for receipt into the system. It will print out kind of a duplicate copy of that. We're currently working on the next release, which should be out sometime early summer of TerraView, and that will include the main feature. That will include an interface with document creation software like CakeSoft and DoProcess. So you'll be able to do a lot of your work in that and then import information into TerraView so you don't have to go and recreate all the same information for 10, 20, 100 documents. The registration hours, this has come up on a number of talks that we've had, so I put those in there. For the electronic submission of documents, it's 8:30 to 5, Monday to Friday. That's for electronic submission. The TerraView hours are different. They're 8 to 8, Monday to Thursday, 8 to 6 on Friday. You can do everything in TerraView except submit your document for registration after 5 o'clock. So you can go in, you can create, you can search, you can do all those things up to 8. You just can't register after 5. Next slide tells you what to expect if you go to the LRO, and again, I would encourage you not to. But if you are going to go there, you need to know what to expect and what the requirements are in the office. You're still going to have to know electronic registration. Our staff are not going to be there to tell you what to do and how you should do it. You're still going to have to know that. After the second reg, if you do go in, we will take a Polaris document, but it's only as an input document. It has no legal status. We'll give it back to you, or we'll throw it out after, but it's only to serve as an input document. You must advise staff what document type, and there are a number in the system, what to use, and what statements are applicable for what you're attempting to do. If there are law statements that have to be used, then the lawyer must be present to make those and provide the Law Society number, because there's a cross-reference back with the Law Society system to make sure that the lawyer is in good standing who's making the statements. You must present ID, and that's new now, but we're only trying to mirror what's happening in the electronic world, where to get your security credentials, you must provide certain information for that. So we're going to be asking for that. And expect it to take substantially longer if you're going to do this, because we now have to do all the document input for you. The last slide I had is just our rollout schedule for this year to tell you kind of what to expect. A couple of dates are already up there. In Dufferin, we've already gone with first reg. That happened a couple days ago. We're going to go with York, Durham, and Ottawa, probably, and I can't give you any exact dates yet, but probably York and Durham sometime spring, early summer, and Ottawa maybe late summer. In second reg, of course, we're already into Wentworth. Halton's been announced. for April 25th. And Peel and Dufferin hopefully will get there sometime in the fall. So that's our current schedule, and that's the end of my presentation. And I thank you, and I look forward to answering any questions you might have at the end.
Thank you, Randy. Our next speaker is Maurizio Romanin, who's a graduate of U of T and a former partner with the firm Delzato Zorzi. He's past chair of the Real Property Executive and is currently co-chair of the CBO Condominium Committee. Maurizio is currently working on the Title Plus project with LPIC and is on the Electronic Registration Advisory Committee. Maurizio will provide an overview of the activity of the Joint Committee on the Registration of Electronic Documents.
Thanks, Leonard. As Randy said, we do have the person responsible for the first electronic registration in the world, and if for those of you who want to watch it, I think Ripley's Believe It or Not is putting it on Fox Network next week because it's so exciting. But anyways, it's Kim Little over there, and anyways. I have to apologize, first of all. I've got a bit of a cold, so I'll be coughing throughout my discussion, and if you'll bear with me, I'll try to get through the discussion as quickly as possible. A couple of things I want to say today. Actually, there's 4 things I wanted to talk about briefly today. I have 15 minutes, and hopefully I'll make use of it advantageously. The first thing I wanted to clear up or clarify is exactly how we're putting these programs on and sort of the educational process around them. This is, I guess for lack of a better term, what I call like the forest type program. It's a higher level program. We're not going to go into the exact details about how everything in electronic registration works. So this is almost like our first program around high level things, and we typically roll it out or do it in conjunction with the first registration in a particular jurisdiction. As you've seen by Randy's presentation, there have been a number of first registrations. So the reason why we're doing it in Toronto in particular is because, and some of you may be getting a little concerned about it, you're getting ringed or encircled by jurisdictions that have e-reg capabilities, although it may not be available right in Toronto. So we thought it's important, since a lot of us who practice in Toronto do a lot of work in the outerlying GTA areas, to start with the educational process and bring on the first program. And by the way, this is the second, or this is the repeat of a program we did about a month ago because the demand was so high for this program. So that's impressive that people are that concerned and want to get out here and learn about e-reg. The second program we're putting on, which is timed a little bit more closely with the second regulation, i.e. the imposition of mandatory e-reg in certain areas, is the more what we can call tree type program. It goes into a lot more detail, talks about exactly some of the issues, how we're going to practice, how we're going to exactly transfer funds electronically for land transfer tax issues, how you set up your accounts, those types of things. So I guess what I really want to impress on people, if you leave today thinking about, let's say, the top 10 things you got to worry about to get ready for e-reg, as opposed to worrying about the most minute detail, that's a very good starting point. So let's try to focus on the forest type things today, get those thought about and resolved in our heads as how we're going to do things, and then focus our attention on more of the details type aspects of electronic registration. Now, a little bit about the Joint Committee itself. It has been around for quite a while. We established it in June of 1996. And why we call it the Joint Committee, first and foremost, is because it was jointly established by the Law Society and the Canadian Bar Association. Okay, so those two organizations got together and thought it's important to establish a committee, and I'll talk a little bit about its mandate as I move through the discussion. But those are the two organizations that originally created the committee. Now, there were membership on the committee from both those organizations, as well as other organizations such as Orella and Cadelpa. In addition to that, we have advisory members on the committee that are representatives of Terranet, the Ministry, LPIC, those types of organizations who are like stakeholders in the system, but aren't practitioners or don't come into the committee as practitioners talking about how we're going to practice. The other interesting and very important thing about the Joint Committee is that it's what I call a very diverse group of people. And what I mean by diverse is it's, number one, geographically diverse. People from all over Southern Ontario, okay, London, Ottawa, all over are on the committee. So it's geographically represents a wide group of lawyers. It's also diverse from the perspective of the type of experience and the type of practice that these people have. Because we have people from large firms involved in our joint committee, we have people from smaller firms, medium firms, sole practitioners. So it represents a wide array of types of practices. So we hope that we've been exposed to a number of issues or a number of views from different types of practice. I just said briefly I'd get to the mandate of the committee, and the mandate, I think, or not I think, I know, okay, in fact, I hope I know after all this time anyways, because it's been 5 or 6 years, is basically to develop a set of practice directives and standards around E-Reg. Now, you've heard a little bit about change and how we're trying to deal with change. And the important thing that we all have to remember is, and wherever we are, whatever type of job we have, frankly, change is something that's inevitable. It's going to come along, and the issue is how we manage that change. And I guess that's what the Joint Committee is trying to do, manage the change, and in fact harness it in a way that can develop benefits for the practicing lawyer. And that's what we tried to do when we developed the practice standards. We developed practice standards that weren't what I'd like to call ivory tower practice standards, that are set standards that are impossible or maybe inefficient or unattainable from the perspective of being able to practice from an economic perspective. They're directives that are helping us or trying to get us to facilitate our use of the system and make it more efficient for us to practice law. To that extent, we did an initial report to the Law Society, and then we prepared a final report, which much to my chagrin, none of you have, or none of you have materials right now, because again, they're lost somewhere in the bowels of the Law Society. But the final report is a very large document, and it's available on the Law Society's website, and it's available through the Terranet's website. And I think you can link in through LPIC's website to these other websites to get them. So if you really have problems sleeping at night, I suggest you get a copy of this, read it through, and memorize all the things in this very detailed report. Now, recognizing that this is a long, lengthy report, what else we did, and which is in your materials, which you don't have, is something called this, okay, which is E-Reg making it work for you. And I'm going to take you through this briefly in a sec. Unfortunately, you don't have it, so you have to bear with us. And it's sort of, again, the top 10 points around E-Reg. It's sort of like a summary or synopsis of the things that were considered and dealt with in this report at a sort of a simpler to understand and a more basic level. And there's about 8 or 9 or 10 points in there that I'll briefly touch on as we go through and through my presentation. Before I do that, though, I just want to touch upon the last thing about the report, which is, I guess, the most fundamental thing that we told the Law Society. This is a new system. As we heard, Kim was the first person that ever registered a truly electronic document. So we, as committee members, felt that we can't be sort of omniscient. We don't really know how this system's going to work. We don't know how things are going to change and evolve as a large body of practicing lawyers sort of attack the system, start to use it, and develop idiosyncrasies around the best way to use it. So we were very concerned about, again, setting up practice standards that made you do things or suggested you do things in a certain way that turned out to be a little bit more difficult than a way that would evolve as we got experience with the system. So we told the Law Society that we consider these to be draft practice directives, directives that we should look to and try to follow, but that have to evolve as the profession garners more and more experience with the system. So that's why we're constantly meeting as joint committee members, reviewing the profession's experience, inviting comments around the directives, because we do want to change them and involve them so they in fact help facilitate what you do and help you use the system in a way that's efficient and basically streamlines your practice. So that's probably the most important thing we all have to recognize about the report. It is, or the directives recommended in the report, they are something that's fluid, are intended to evolve, and are intended to change as we get some experience with the system. Now, if I quickly review with you the things at the top of working with E-Reg, which again you don't have, the first thing is the Joint Committee's mandate, and I briefly talk about that, and I'll reiterate it again. It's to develop practice directives that facilitate, and I emphasize facilitate, your use of electronic registration. Let's see if we can figure out ways to make it easier for lawyers to do their business given this electronic tool that's being developed in the province. Creating the documents. Well, that's a basic point that we put in the thing, put in the summary report here, and it's intended to emphasize that documents are created by the lawyers online, reviewed by each of you online, and then signed electronically online. So what you're doing is you're signing the documents both from a completion, i.e. I like the form, it's okay, the information, the correct information is there. You're signing it from that perspective. And you're also signing it to evidence your consent or willingness to have it then go registered. So there's two sort of electronic signatures, and I emphasize electronic. No one's actually physically signing anything. It's a mathematical or a computer type algorithm that generates a thing onto the document evidencing your consent to it. So that's how the documents are created. They're created online, reviewed online, and signed off on online. One of the things that the committee found was very important, and we put it right into the directives, is what we call having the right technology. Simply put, to produce registrable documents under electronic registration, you need the right computer equipment and the right software, and you need to know how to use them. Whether you like computers, whether you don't like computers, that's the reality of the world we're in. You're going to have to, in order to practice and to practice properly, the committee's view was you've got to get a computer, you've got to get it online, and you've got to be able to do this stuff. There's no sort of sitting in the back corner saying, I'm never going to get a computer, I'm never going to get a computer. It's not going to work. Compliance with law statements. That's an important thing. Kate touched upon them briefly. I'm not going to go into a lot of detail with them this morning, except from the perspective that they are there to replace paper filings. They're based on the fundamental premise that we as lawyers should be able to, as professionals by the way, should be able to rely on each other's expertise when we make a compliance with law statement, so that we don't have to go behind those statements and understand all the supporting evidence, or not understand but review all the supporting evidence that allowed someone to make that compliance with law statement. In other words, if I make a compliance with law statement on an electronic document, you should be able to take it in face value. In simple terms, I've complied with the Mortgages Act and this power of sale. You should be able to take that on face value, and the system should take that on face value, so you can rely on it subsequently. That's what we tried to do with compliance with law statements, and we tried to create it specifically for lawyers, recognizing that they're very qualified professionals who should be entitled to make these types of statements. Client approval of prepared documents. Again, an issue that we looked at, had to deal with, because remember, as we go through the system today in paper, your client comes in, signs something. Well, that's very simply prima facie evidence of your client's consent to the transaction. If they're signing a charge, you can pretty well have some proof that they consented and wanted to go ahead with the mortgage. In the electronic world, you don't have that paper backup. So you have to worry about that, and in fact, we've created what we call an acknowledgement and direction, which is intended to evidence your client's consent. It's a piece of paper that the system generates, evidence your client's consent to the transaction itself. And again, you can use the systems, you can create your own. It all depends on how you want to do it from the perspective of the forms that are utilized. The closing itself. We recognize that there may be important changes on how this is going to happen. In particular, what eReg does is what eReg does is it allows you to close deals remotely. Okay? Whether you're going to take advantage of that opportunity is really up to you in your practice. You can still meet at the registry office and do those things, or you can take advantage of this remote capability and try to develop a practice around there. If we wanted to take advantage of this remote capability, there were certain steps and certain procedures that we thought were important for the legal profession to use. And again, we put those forward, created what we call, and what everyone's probably heard about, as a document registration agreement to sort of facilitate that remote closing capability. Because the important thing around eReg and electronic registration is that capability to close things remotely or to register remotely. Again, I briefly touched upon document registration and how we'd be signing them for completeness and release prior to registration. So again, there's two signatures, and the issue about how law firms are going to deal with delegation of that authority, or when it's appropriate to delegate that type of authority, i.e. when and if, which we suggest you don't do, you should be handing out your pass cards and things to different people in your office. Okay? That is something we've looked at very closely, and we feel very strongly about that type of practice should not go on. Funds transfers, how you're going to deal with moving funds that from your trust accounts that represent land transfer tax and registration fees. There's two practices or two proposed ways you could do this, one from a general account, one from a special trust account set up to deal with funds that are going to be electronically moved into Terranet's accounts. And again, we go through that and talk about that in a little detail and what's best for the type of practice that you have. So again, funds transfer is an issue that you've got to get your head around and figure out how you want to set up your practice in the context of VREG. Mortgage transactions, a very important area that we looked into, particularly first when it comes to the Mortgages Act. That requires, for instance, that you deliver a paper copy to the borrower as part of the requirements for having a valid mortgage. Well, that's gone through and we looked at that, and the red tape revisions have made it clear that the type of copy you print out, for instance, from eReg is sufficient to deliver to the borrower to meet those requirements under the Mortgages Act. The issue about discharges and undertakings, because if the financial institutions, which they've indicated that they are going to do, are handling the registration of the discharges themselves directly, what should your undertakings say? Because your undertakings today say, I'm going to procure and register. Well, you're no longer registering a discharge if the financial institution is going to be doing that. Secondly, well, it's great that they're registering it. How the heck do I find out it's registered? Am I going to be constantly going into Polaris and reviewing or sub-searching title to make sure that, in fact, that discharge has been registered? Those types of issues we've looked into and are dealing with and are set out in the report. Again, guarantees under mortgages. Remember, you heard Kate Murray talk about the changes to the Land Registration Reform Act, which basically overrule what we know as the statute of frauds and says you don't need a paper signature. But in the context of a guarantee, okay, that's a contractual document. You still need a piece of paper to sign to evidence the guarantee. So again, we have to sort of excise that out of the mortgage, which we usually had signed, and that included a guarantee, and have a separate guarantee now to make sure that we have a valid and binding guarantee if we're looking at guarantees as part of a mortgage. We also looked at security of the system, how the system is secure, how we can make sure that the users use it correctly, and again, how we can make sure that firms control who has access, because remember, first and foremost, the beauty about the system is it does leave a lot of what I call footprints, electronic footprints. It knows exactly through the credentials who's been there and used the system and done what to the documents. Well, it's going to be up to us as lawyers to manage that process from the people inside the firm whom we want to have access to the system. We want to make sure that when people leave, their credentials are turned in and they're turned off so that they're no longer accessing the system under our accounts and things like that. So there's a bit of a management process that we all have to look at and figure out how we're going to do this. If, you know, in the sole practitioner context, it's a little bit easier because it's me and my card, and I'm not worried about anybody leaving. But if you have 2 or 3 employees or clerks or conveyancers or anybody else who may be accessing the system under your credentials, let's make sure we're managing those properly so that there's no improper access under the system. And again, delegation, which is a big problem. Okay, a big issue around lawyers who are unwilling to use a computer or look at a computer, who are coming upon this as thinking that they're just going to turn over everything to a clerk or assistant and never have to push any buttons on the system. And I think, and I'm cautioning all the lawyers out there, this is going to be very problematic from the perspective not only of how the system works and how the security around the system is designed, but from the perspective of the type of practice and the type of sort of image we want to portray as a profession. Because we're constantly out there struggling to maintain our position in the real estate practice and saying that we're very essential to this practice, but at the same time, we're sort of completely, or some of us want to completely delegate every type of special authority and privilege that's given to us as practitioners to people who aren't lawyers. So we have to be very careful about that from both our own internal security systems and from the future of the practice itself. That's basically the report and the summary. I hope I haven't gone over my 15 minutes. We will have questions later we can field. And again, thank you very much for bearing through this discussion with me. Thank you.
Our next speaker this morning is Katerina Galati. She's Counsel Advisory Services to the Law Society of Upper Canada. Ms. Galati will address the topic of the transfer of funds, and in particular the vehicles for payment of land transfer tax and registration fees.
Good morning. I'm going to be speaking to you today on the types of accounts you may use for the payment of land transfer tax and registration fees in electronic registration and the Law Society requirements. I'm going to first provide you with some background information. Then I'm going to discuss the two options that you have, the use of the special trust account or your general account. And third, I'm going to review with you some of the items that you might want to consider when making your decision. Just by way of background, with the rollout of electronic registration, the Law Society had to consider viable methods for the electronic payment of land transfer tax and registration fees. The TerraView Electronic Registration Systems Agreement, which is the agreement that an account holder signs with TerraNet when he or she subscribes to TerraView, is structured in a way that the submissions of instructions to register documents constitutes authorization to TerraNet to debit predetermined sums for land transfer tax and registration fees from an account designated by the lawyer. So let's look at the trust account option. The question you may have is, why can't I simply just use my mixed trust account? The Law Society considered this option, and we felt that it was not a viable option for two reasons. In e-reg, non-lawyers would be registering documents and therefore transacting trust funds. Secondly, a third party, TerraNet, would be debiting the trust account. Our bylaws generally do not permit either of these. In fact, they are both contrary to the very principles underlying our bylaws, that is, the integrity and protection afforded to client trust monies. So the Law Society was faced with a difficult task. Our aim was to establish a method that would permit the debiting of a trust account by a third party, but that would at the same time preserve a comparable degree of protection and integrity over client funds in the trust account. Also, we wanted to establish a method that would create as much flexibility as possible for lawyers. The result was an amendment was made to Bylaw 19, which now permits a lawyer to establish a special trust account. What is a special trust account? Basically, it's like a clearing account for the payment of land transfer tax and registration fees. From a banking perspective, it's the same as a mixed trust account. It's not an e-account, it's not a special electronic account. It's to be used only to authorize TerraNet to debit the account for land transfer tax and registration fees for specific clients and transactions. All of the requirements and restrictions that apply to trust accounts generally will apply to this account. This account, though, has some special features or restrictions. They're contained in Bylaw 19, and I urge you to read the bylaw, but I will highlight some of these features and restrictions. You can only deposit monies into this account for land transfer tax and registration. You must deposit exact sums of money. You can't deposit more than you need, and if you do, you have to correct the error, move the money back into your mixed trust account. The funds must relate to a specific transaction and client. The funds can be kept in this account for a maximum of 5 business days. The lawyer must complete, date, and sign an authorization form, which is Form 19B contained in the bylaw, prior to registering, that is, prior to authorizing TerraNet to debit the account. This form is to be kept in your file. After registration, TerraNet delivers a confirmation form to the lawyer. The form is printed from the TerraView system. The confirmation is to be received by 5 p.m. on the day immediately after the day that the withdrawal is authorized. The confirmation will contain the amount of money withdrawn by TerraNet. The lawyer must then do a reconciliation. He or she must compare the amount contained in Form 19B with the amount contained in the confirmation. The reconciliation must occur by 5 p.m. on the day immediately following the day that the confirmation is sent by TerraNet. If the amounts balance, the lawyer will sign and date the confirmation. If there's an error, TerraNet must be contacted immediately, and the error must be corrected. So how does this work from a practice point of view? In the materials, there is a diagram that illustrates this, and I would ask you to follow with me if you had it, but I'm just going to try to explain briefly. First, you receive funds from your client. If you receive one large check, that is, including the closing proceeds, your retainer, land transfer tax, and registration, you deposit this check into your mixed trust account. You then prepare a check to your firm in trust in the amount of the land transfer tax and the registration fees, and you deposit this check into your special trust account. If, however, you receive a separate check in the exact amount of the land transfer tax and registration fees, you can deposit this directly into your special trust account. However, bear in mind that you must comply with the requirements, the time requirements of Bylaw 19. Monies can only stay in the special trust account for a maximum of 5 business days. You then complete your Form 19B. You then register. You print your confirmation, and you do your reconciliation. You compare Form 19B to the confirmation, and then you report to your client, and you include an explanation of the trust transaction. And that's all I have to say about the special trust account. The general account. You can use either your existing general account, or you can set up a special general account to deal, or a separate general account to deal with the payment of land transfer tax and registration fees. If you use your general account, the payment of land transfer tax and registration fees is treated like any other disbursement that you would make from your general account. From a practice point of view, how does this work? Well, you receive client funds and you deposit them into your mixed trust account. You then prepare a check to your law firm in the amount of land transfer tax and registration fees. You then proceed to register. That is, you authorize Terranet to debit the general account for the amount of land transfer tax and registration fees. Thereby, you incur the disbursement. You then should print a confirmation from the system just to verify the amount of the disbursement incurred. And then you're in a position to deposit your trust check into your general account. And then you can proceed to bill the client. Although it is a preferred practice, you're not required to bill the client prior to transferring monies from trust to general for an expense incurred on behalf of the client. Now, the question I normally get asked in advisory services is, which account should I use? The Law Society has no preference. In fact, we've tried to leave it as flexible as possible for you. You should consider which option best suits your practice. You should consider which option best suits your accounting system and procedures, the size of your firm, the availability and use of support staff, the manner in which you conduct your practice, the type of practice that you have, the volume, the types of transactions, the location and hours of operation of your bank. With respect to the trust account option, we have identified a problem. Basically, under the TerraView agreement, you are only able to designate one account for the payment of land transfer tax and registration fees. Our bylaws are such that you can only deposit client monies into the trust account. So if you wanted to do a registration where you do not have trust monies, you run into a problem. We have identified this as a problem. We are going to be re-examining our bylaw, and we will keep you informed of any amendments. To conclude, I wanted to make you aware of some resources that are available. We do have a website, and there is information on electronic registration, and we are in the process of updating it, so I encourage you to visit it. In addition, the Ontario Lawyers Gazette will carry periodic articles on electronic registration and developments. And finally, if your questions cannot be answered by the website or the materials, please call us in advisory services. Thank you.
Thank you, Katarina. Our next speaker this morning is Kathleen Waters. She's a graduate of U of T and a former partner with Torkin Maines, Cohen & Arbus. She's currently Vice President of LPIC and responsible for the Title Plus project. Kathy will be speaking on errors and omissions and the use of compliance with law statements and document registration agreements.
Well, good morning, everyone. I'm wearing a bit of an unusual hat in comparison to when you normally see me, because today I am speaking on behalf of LPIC as a whole. I am a member of the Joint Committee on the Electronic Registration of Title Documents. I'm a CBAO designate on that committee, but I also keep an eye out for LPIC's interests while I'm there. And LPIC has actually been involved with the whole regulation process and the Joint Committee work for quite a number of years. And there are 3 issues that came up over the past few years that we were fairly involved in that I want to tell you about today. The first issue that came up was the document registration agreement. Now, you've heard about that a bit this morning, but basically the document registration agreement is the form of escrow agreement that you will use to exchange your non-electronic documents and funds and keys, probably for some period of time. And there was some concern that some lawyers would be nervous about entering a document registration agreement with other particular lawyers, or maybe about entering it at all. You know, people were asking questions like, well, from a negligence perspective, am I going to have to check out that I can really trust this law firm on the other side before I send the check over to them in escrow? I don't know that firm, or maybe I think they've got problems, whatever. And we were really afraid that that might lead to some firms saying, well, you know, we'll close together, but we're not going to close together with anybody else in escrow. So LPIC took the position that in terms of its errors and omissions program, it will not require payment of a deductible or payment of a claims history levy surcharge if you are sued because the lawyer on the other side of the document registration agreement breached the agreement. So you can enter the agreement with the lawyer on the other side, and if you're worried that something may go wrong and your client's going to end up suing you, but it's not your fault, it's the other lawyer who broke the agreement, you will be protected from a financial perspective in terms of your relations with LPIC. And the form of document registration agreement approved by the Joint Committee is on the Law Society website. Another issue that came to LPIC's attention related to the compliance with law statements. And in LPIC's view, there should be no need for a lawyer who has no adverse knowledge to check up on the grounds being used by the opposing lawyer to make the compliance with law statements. As part of our work together as professionals, the view was taken at LPIC that even if the statement is being made to close this pending transaction, if that other lawyer is prepared to make that statement, you should be able to rely on it. So once again, LPIC would waive any deductible and claims history levy surcharge if a negligence claim is brought against you because you innocently relied on the statement being made by the other side. Now, in both of these areas, the DRA and the compliance with law statements, that's not to say all kinds of ugly things may not happen to the lawyer who breached the DRA or who incorrectly made the compliance with law statement, but the innocent lawyer does not have to worry about an adverse financial penalty. The third area that interested LPIC related to this issue that with E-Reg, effectively it's the lawyer signing the documents through putting the electronic signature on the documents rather than the client signing the document. So I think Maurizio, for example, referred to the fact that historically, when the client has signed the mortgage, that's pretty good evidence that the client was authorizing you to go ahead with the mortgage transaction for them. And we were particularly worried that the lawyer may be going to be held responsible for factual statements made in the electronic registration. Because remember, there's factual statements there like the spousal statement of the client, the age of the client, etc., when in the vast majority of cases, the lawyer isn't going to have any personal knowledge of that information. And of course, Section 57 of the Land Titles Act states that a person on whose application an erroneous registration is made is open to a claim from the person who's wrongfully deprived of the land. So, you know, by the lawyer now making those statements, was that section going to impose liability directly on the lawyer for that? Well, we tried to deal with that in 2 ways. The first way was asking Teranet to build those acknowledgments and directions that you've heard about earlier, that the system will automatically generate for you, that confirms all the information that you've put into the electronic document, and your client signs it saying, you know, yes, I've read this information and it's correct. So there's less chance of the client coming back afterwards and saying, oops, did I tell you I wasn't married? Gee, I must have been wrong about that, right? And you're sitting there with no evidence to the contrary of what they said in some conversation. So this gives you an easy way off the system to hit a button and produce an acknowledgement and direction on those issues. The other thing that we did with the ministry was actually to get a section added in to Reg 1999, which is section 40 sub 3, which provides that the lawyer is deemed not to be the person on whose application the registration is made. So the client is going to remain primarily responsible for any such errors. And then, of course, just the same way as in the paper world, as between you and your client, if you've done something incorrect, yes, the client may turn to you, but at least at first blush, that application is being made by the client for the purposes of the Land Titles Act. So those are the three areas that we've been quite involved in. In terms of the issues on deductibles and claims history levy surcharge, there is an article on that on the LPIC website, www.lpic.ca, if you want to see confirmation of that in writing. And thank you very much.
We'll put aside now about 10 minutes for questions. To let you know, the materials are here now, so at the break, which will follow immediately after this, everybody can pick those up. I'm going to ask Maurizio, actually, to come up. He's going to help direct some of the questions to the appropriate people here.
Thanks, Len. Go ahead. Okay, well, first I'm going to repeat the question because I think it's being taped or something. So I think the question was, can you not use your existing account, which is your credit account with TerraView that you're doing searches through for the purposes of electronic registration and moving the funds? I guess I can answer that, looking around. I can answer it fairly quickly. The simple answer is no, unfortunately. That's the simple, bad, short answer. What we're looking at, and this has been raised a number of times, we're looking at changing that relatively quickly because there should be no reason why you shouldn't have that type of choice and flexibility. So no, but it's qualified because I think it'll change. The gentleman at the front.
No,
Randy, can I ask you to repeat the question first, just so for the purposes of...
the question was, does it prevent, or does electronic registration prevent a lawyer who does not want to, a non-lawyer, okay, sorry, a non-lawyer does not want to buy a computer from attending at the registry office to do work there? And again, the short answer to that is no. I mean, we continue to have a public office that people can attend to and use our staff much as they do today.
The gentleman at the back. So I think the question is, right. I think the question is, can you put your own money into the general account as in order to fund it for purposes of land transfer tax and registration fees in connection with electronic registration? And the simple answer is yes, but I want to go on to say that when you use these accounts, the money doesn't come out till the end of the day. So you do have the opportunity, because I noticed that there was a lot of people concerned about having to sort of fund these things out of their own pockets in the interim, but the money doesn't come out at the end of the day, so you do have the opportunity to actually transfer the actual funds in the general before the money's come out, even so you don't have to use your own funds in that context. So you don't necessarily have to fund land transfer tax and or registration fees yourself. Exactly. You definitely can. That's your opportunity, yes. Thanks.
Can you use two accounts, special trust account and your general account for, let's say, your search fees and your preliminary written search fees, and your special trust account for the actual deal on that day?
Well, remember, you have a deposit account right now, which some of us have that are doing searches, that you put money in, and most of us maintain some type of balance in there. And that's the account that typically you'll be paying search fees, writ fees, and those things out of. Okay, so that's one account. And then you have to designate an account from E-Reg perspective that will take the land transfer tax and registration fees out of. So you are in effect using two accounts. The problem arises because you can't use both those accounts for E-Reg purposes, purely E-Reg purposes. Well, then maybe something's changed because I'm not aware of you being able to. Well, maybe you should come on up here and answer the question. How's that? But I was hoping there was someone from Terranet there. Val, can you answer that? The access, the accounts you can access through E-Reg? But the deposit account is not available for land transfer tax and registration fees right now, right? And you have to pick one or the other type of account, i.e. the special trust or the general account right now as your designated E-Reg account. You can't sort of jump between two of them right now, my understanding is. There's a lady at the back. Yeah. So there's even more back, yes. Okay, I think there's two questions there. One, okay, well, I'll try to summarize them and then we'll get answers. Number one, what happens if a lawyer's not available to make a compliance with law statement? And number two, what happens if there's not a lawyer involved in making the document? Okay, well, okay, registered, we'll talk about that, but registered and completing is two different things, first of all. Okay, so maybe I'll ask, does anybody want to answer this?
I can answer
I'm
part
supposed
of
to be
it.
the moderator, not the sole question answer, so.
Okay, let me,
Go ahead.
let me start with the question concerning being able to register without using law statements. The regulations don't make law statements mandatory. You can still file the supporting documentation that you do now in a power of sale or some of the estate matters. I think when you go in and see the difference in how easy it is to use the law statement compared to filing that documentation, lawyers will be using the law statement. But what you have to do if you choose not to use the law statement or you can't because you're not a lawyer, you have to then essentially file that information with us at the registry office. You're given a number and you refer to that number in your electronic registration.
So I guess we have to answer part two. I guess if there's lawyers not around. Well, I sort of looked at it from the same perspective as Planning Act statements. Who's signing your Planning Act statements? You must have a lawyer in the office who's going to sign your Planning Act statements if you're obliged to give them. So the same type of issue would arise, wouldn't it? And the concept is this is something that's signed when you sign a document for completeness, not for registration. So the document can be created and signed off as complete, and then somebody else can sign it and okay? Alan?
According to the joint committee, one lawyer is computerized and one is not. The non-computerized lawyer is supposed to attend to the office of the computerized lawyer to close the deal. Day of closing, that non-computerized lawyer refuses. How do you suggest we practically handle it?
No one else is jumping to answer this question. Okay. How do we deal with a situation, really, when you have and I don't think the situation is any different than the paper world, frankly, when you have a recalcitrant lawyer on the other side, because, frankly, I've had real estate deals where I ended up preparing all the other side's documents, right? Very simply because, and I was pissed about it, frankly, but I had to do it because I wanted to close the deal, right? And And I think that's, if we take that into the context, Alan, I think you're faced with the same thing. We said as professionals who have courtesy to each other, if you're not prepared to practice in an electronic environment and you're disaccommodating someone else because of that, then you should be sort of at their preference, okay? And if the person isn't, I would suggest that call it in, speak to somebody at the Law Society, let them know perhaps, because, you know, unfortunately, we don't have E-Reg police or anybody out there that are going around, but I think it's a matter of professional courtesy, frankly, and, you know, if you want to be courteous to the other side of the deal, that's what you should do, and
Ask the lady from the professional complaint. Would it be grounds for professional complaint if the lawyer refused to close and you had to go to the registry office?
There is a rule that deals with courtesy among lawyers, and yes.
How long would it take to process?
I don't think. I think that's a fair assumption.
Gentleman at the front.
Okay, so I wanted to just clarify where we're registering a document where there's no land transfer tax. For example, if I want to register an application to amend the register because of a change of name, are you saying that we cannot transfer the $70.70 from our general account into the special trust account?
Well, you have to one account for the purposes of paying the registration fee or land transfer tax. So if you've designated your special trust account, you require client trust monies and you deposit them into your special trust account, and you can use that in order to pay the registration fee.
But for example, if we don't have any money from the client, right now we would simply issue a general account payment, and it's
Right.
in the manual system we would pay it out of the general account by way of check. So are you saying that we cannot, if we have no client money, we cannot transfer from our general account the $70
Yes,
into the
that's correct. That's the way our bylaws read. You can't deposit, it's a principle of just trust monies. You can't deposit your own monies. You can't mix your own monies with trust monies.
except because if it's a special trust account for registration,
We understand, we've acknowledged that it's a problem. We are going to be looking at it, and it may very well be that it will be amended to allow you to do that, but it's still at the preliminary stages.
We're dealing with looking at changing that as soon as possible through the joint committee, okay? Well, why don't I do this? Why don't we have the break, because we're going to have a rest of the program, then we can take the questions at the end if you want to stick around. So let's have the break, and then we'll do some more questions.